Hello, and welcome to our community conversation series between Safe Harbor, Sheboygan County, and the District Attorney's Office of Sheboygan County. My name is Vanessa, and my role with Safe Harbor is volunteer and community engagement. Our goals with this series are focused on creating a greater understanding of community agencies and that victim support survivors of sexual assault may report to, along with gaining clarity regarding the roles of those agencies, the mechanisms of their support, and the resources available through those agencies. The series is also focused on creating more awareness regarding the options available to victims and survivors so they're able to make more informed decisions about how they wish to navigate community resources. Today, I'm joined by Joel Urmanski, District Attorney of Sheboygan County. Joel, welcome. And could you begin by introducing yourself and speaking on what your role and responsibilities are as Sheboygan County's District Attorney?
Of course, Vanessa, and thank you for having me. I think this is a great topic, and I'm glad that there's this communication in our community. I'm the District Attorney of Sheboygan County. As you've heard, I've been the District Attorney since 2017. Before that, I was an Assistant District Attorney in the office. My entire professional career has been as a prosecutor in this county, in this office, and this is now year 15. This is the job I've always wanted. I never wanted to do anything else but this job, and certainly would never want to do defense work, and that's just my priority. And that's because we get the chance to help victims, survivors, every single day. Our job is to make sure that everyone in our community is safe, whether they're living in this community, working, or going to school in this community, shopping in this community, or just happen to be passing through. We want to make sure that everyone feels safe and people who violate the law are held accountable for what they've done, while also giving them an opportunity for rehabilitation so that they do not commit similar crimes again. And a large piece of what we do is trying to take care of our victims. We realize that individuals coming to us are sometimes in the worst places of their life. They've had something very tragic happen to them. And our job is to try and help them. It's connection to resources. It's understanding the traumatic episode that they've gone through, which may or may not have been the first traumatic episode or similar episode they've dealt with. Is to answer questions, is to be there for support, and ultimately to help the community. And we have a full staff of people, attorneys and otherwise, that work with us to try and accomplish those tasks.
Awesome. What does your team look like, and how do you assign cases?
We have 9 total attorneys, and that includes myself. And then we have a whole host of administrative staff and also staff in the victim witness office. Dion, in fact, is one of those staff members who is going to be a part of this particular program. Our attorneys are assigned cases based on the timing when they come in. So the courts function on what's called an intake cycle, where one judge for a period of 6 weeks is assigned to all of the cases that are committed in that time frame. Our prosecutors work under a similar circumstance. So the attorney who happens to be on intake at that time is reviewing cases that come into the office at that time, with the exception that there are some cases that either myself or the deputy district attorney will step in and take. Sometimes those are the cases that may take the longest amount of time to prosecute, or maybe the more significant cases. I take pride in how our office handles sexual assault cases, and oftentimes we'll jump in on those. Certainly that includes human trafficking, and sometimes in very serious domestic violence cases as well. Although for domestic violence, a misdemeanor case can have extremely serious history. So it's hard to say one domestic violence case is more serious than another. So there are ultimately 9 attorneys that someone as a victim survivor may have to be dealing with. And we try and have those attorneys stay consistent so that someone's dealing with the same attorney, or sometimes there's some coverage. There may be a second or even a third attorney, but primarily is able to build some rapport, strength, and confidence in one of the attorneys. And then same for victim witness, there are 3 specialists in victim witness, one who handles all of our domestic violence cases and the other who handle the other workloads. And we try and provide consistency where the same victim survivors working with the same victim advocate as well. So as far as assigning cases, it could go to any of those attorneys and victim witness staff, and we try and keep that consistent through the life of the case.
Excellent. Thank you for sharing that. So how involved is the charging attorney prior to going to court?
So the charging attorney's duties are very significant. First of all, they get the reports from law enforcement. Most of the time, our office is able to make a decision on whether charges should be filed and what charges to file just by reviewing them. An important aspect of our work in the state of Wisconsin is that victims are not the ones who press charges in the state of Wisconsin. It is the members of the district attorney's office that make that decision. So there may be a victim who calls and says, I do not want charges to be pressed, but we make the decision to do so. Similarly, there may be a victim who calls and does not want charges to be pressed, and we feel an obligation to file charges in a case. So that discretion ultimately comes to us. And there's a lot that we take into consideration. We view the reports. We determine what law enforcement has collected. At times, we ask law enforcement to go out and continue their investigation. It may mean they have to talk to more people. Maybe they have to speak to the same people again. Maybe we're looking at warrants so that we can search residences or vehicles. Maybe it's to search a phone or a computer. Maybe we're looking for some biological material. We want some DNA samples from individuals. There's a lot that goes into the decision, but sometimes there's more evidence gathering that takes place. We look at prior histories. We read written statements. We consider what victims have to say. I just told you that we're the ones that make the decision, and that's true. The way I like to say it is that we're the ones driving the bus, but that passenger is right there in the seat behind us, and we listen to what that victim has to say because it means something to us. In addition to that, sometimes we're looking at photos or listening to recordings. Sometimes we also meet with victims in advance and have a discussion about cases, facts, and circumstance. So there's a lot that goes into that decision, but ultimately at the end of the day, we make a decision on whether a case should be filed, what charge or charges should be issued, and then we move into court. And prior to that initial appearance, the first time that defendant is going to be in court, the victim gets notice and has the ability to engage in that hearing. They can, these days, call or Zoom into court and just watch. Don't even have to say they're there. They may want to say something, whether that's on video or via phone, and they can do that. But no matter what, it's with the ability not to be named. In our complaints, we identify people as victim 1, victim 2, victim 3. We don't put people's names out there. We understand that people are very afraid of that and what it can mean for people, so we don't include it. And courts aren't going to ask it either. So if you attend court and you want to make a statement, you can say, I'm victim 1 and I would like to share this, because we know how important it is that really the last thing that most victims want is to have to be a victim and be in court. We try and prevent them from having to engage when they don't want to have to engage.
Great. To further expand on that, at what point does the risk for community safety outweigh the victim survivor's wants or requests?
It's a very good question, and one that can be a little complicated to answer, but in a general sense, as a prosecutor, our obligation is that we are employees of the state and we're working on behalf of the state and the county. When it comes to what outcomes should occur from an investigation or a case, we have to consider what is the gravity or seriousness of what the defendant has done, what is the need to protect the public, and what is the defendant's character and need for rehabilitation. And we consider those factors and have long discussions about those factors. We do not want to have to try and force a victim survivor to have to go to court or be involved in the criminal system. We don't get involved in cases ourselves unless law enforcement brings them to our attention. So there are times that there may be crimes we never know about. And while I would love to know about all crimes so we can take responsibility and action for them, we don't know about every crime that's happening. We consider, when it comes to the decision of whether to issue, even if a victim does not want to, how serious is this crime? Sometimes offenses are so serious that even though that victim does not want to be involved and we understand why, we determine that we have to engage in filing a complaint. Same thing, maybe we have a concern that the community is not safe if we don't file a complaint. So we can get bond on the person, which are the rules they have to follow moving forward. Or because we want to get supervision or some sort of sentence to try and control their behavior and make sure it never happens again. And maybe we're aware of other facts and circumstances a victim survivor is not, and we make the decision that for this particular case, we need to proceed forward. I'll tell you, it's not an easy decision. And when we make that decision, we want to make sure that even though that victim survivor may not be happy with the decision, that victim survivor has all of the rights and resources available to him or her, and that includes being as involved or not involved as they want. The only way that we would force a victim survivor to have to engage in the system is if the case ultimately goes to trial. We would try and do everything we can to have the case proceed without a victim having to testify, but it's certainly possible they may have to. But even when that happens, we would have a nice long conversation, not telling a victim survivor what to say, that's never appropriate, but to let that victim survivor know the questions we'll ask, to let that victim survivor see the courtroom, to ask questions and hear about the court process, to visualize what it might be like to sit on that stand, and also to play the part of the defense attorney so that victim survivor can get a sense of those questions. I remember one vivid case where a young person, a teen, but still a young person, had a problem and was unwilling almost to even answer questions for me preparing for trial. It was that reluctance, it could be embarrassment, it could be so many different things unique to each person. But after we talked and after we saw the courtroom, we got in there and this victim survivor did it. And I'm not saying everyone can, but I'm saying we do everything and anything possible to get that person to that point if and when we determine that it has to go that way.
Great, thank you for clarifying that. Next, can you talk to me about the differences between the very popular TV series Law & Order SVU and the actual timeline that court proceedings would go?
Law & Order is entertaining, and the criminal process is not. When a case is started, if it's a sexual assault or a very significant exposure possibility in a domestic violence case, that case could take anywhere from 9 months to a year, sometimes over a year before there's a final resolution. And that doesn't mean going to trial. That could be a case that they enter a plea and we have sentencing. So it can take a very long time. The other thing is, it's just not as entertaining as you see on TV. There's even a rule in Sheboygan County that attorneys are not supposed to stand when they're asking questions. They're not going to pound their fist on the table. They're not going to approach and argue you can't handle the truth. They're not even to raise voices. It is a much more simplistic system. It is not the entertainment value. It is not filled with moments where there's video to try and reenact what happened. The victim survivor can be on the stand anywhere from half an hour to more than that, depending on the case. There are officers and so many people testify in advance. So a lot of times I actually have a concern that our jurors come in expecting this to be like Law & Order, or maybe expecting the judge to be like Judge Judy. And we have to let them know that it's very far from the truth. Those things don't happen. There's a lot that you see on these TV shows for entertainment. There's a lot that's seen on those TV shows that can intimidate and make victims and survivors fearful. And those things just don't happen in real court.
Great, thank you for clearing that up. During the course of an investigation, a victim survivor might have questions. What does this communication between you or one of your attorneys and a victim survivor of sexual assault typically look like, and how does that communication occur?
So when our office engages in a case and files a case, we send to the victim a copy of the criminal complaint, which is not all the police reports, but it's a document that summarizes very minimally what we allege to have happened. In addition with that, they have a whole list of the rights that they have as a victim survivor, and they can exercise all of them, none of them, whatever they would like. In addition, we give them access to the court. Whether they want to participate or not, they have the ability to know what's going on for at the very least that initial appearance. And if that victim or survivor wants to know about future hearings, they can know all about them, whether they want to participate or not participate. Victims have the ability to file a victim impact statement, which is a written statement about how the crime affected them and what they'd like to see as an outcome. Some victims don't file those statements, but they come to court and either want to say something to the court or read a statement to the court or have someone read a statement for them on their behalf. We will be as involved as a victim wants us to be, so people can call us daily and we can answer questions. If they call outside of work hours or on holidays, they can leave a voicemail, and our staff is wonderful getting back to people and answering questions that they leave on voicemail or questions they may email to us. And as far as the prosecutors, victims have the right to ask to confer with that prosecutor. So we can set up a meeting, whether that's virtually, via phone or in person, where we can meet with that victim survivor and answer questions and have a discussion. It's important that as an office, we speak with victim survivors, not at them. We are not any more important than anyone else. We want to get to know that victim survivor. We want to let them know that we understand that they've gone through something traumatic and we are there for them. We're not their attorney. We're not going to do everything a victim survivor may want us to do. We have independence to do the right thing that we think is right. Sometimes victims agree with that. Sometimes victims don't. Sometimes people think that we're being too harsh. Sometimes people think we're being too lenient. Sometimes agree spot on with what we're doing. But we confer. We can answer questions as much as need be. We can be as involved as that victim survivor wants us to be, because we understand sometimes victim survivors just don't want to be involved, and we're not going to try and force them to answer questions for us and engage, again, unless we have that jury trial and we feel an obligation to do so.
Great, thank you. Another question I have for you today is recognizing that victims and survivors of sexual assault have experienced a high degree of trauma. What does that trauma-informed care look like for the DA office?
So number one, we've looked through all of the communications and letters that we send to victim survivors, trying to make sure that it considers trauma and being trauma informed. In addition to that, we try and arm victim survivors with information. So for example, there's a pamphlet that we share about the court process. One issue that sometimes causes confusion is when a person is charged and they get an attorney, they may get a private investigator. And that's someone who works on behalf of the defense or the defendant to try and ask questions and investigate, much like law enforcement does. We let victims know that you can speak with that person all day if you'd like, or you can say, I don't want to talk to you. And every individual victim, survivor, and witness gets to make that decision for themselves. So we try and arm that victim survivor with knowledge and with some degree of power and control back in their lives. That power and control having been taken away from them by the person who committed that crime and that wrong. In addition, as an office, we engage in training for our prosecutors and our staff, so we understand trauma and secondary trauma, so that we are communicating with and not at when it comes to talking about these cases. We can talk about court process. We can give tips of things you can do to try and make getting through that court process as minimally painful as possible. Even right now, we're in the process of evaluating whether we can have an emotional support dog come to the office and even be a part of our office, so that when victim survivors come in, and that's a traumatic incident to come in and talk to a prosecutor and talk to someone about something you don't want to have to talk about, but to have a support animal there, you should see the smiles on faces, young and old, when they see that dog there. And it's a simple trick, and it's a simple sitting there that makes a huge difference. And we try and consider all the ways we can be trauma-informed to help that victim survivor get through the process and the system.
Awesome. Thank you so much. Now, I just have one final question for you today. We appreciate talking with you. So the last question is, if there was one thing you wanted Sheboygan County and its communities to know about your role with victims and survivors, what would that be?
There's a lot, you're minimizing me to one, so that's hard. I think what's important is that we care. We care a lot. We've had a lot of prosecutors come into this office from retirements and a variety of things, and the interview process is pretty rigorous. And we ask a lot of questions because we want to make sure that the prosecutors that come into the system, into our office, realize that one of the first considerations they have to have is, what is the harm that was caused to a particular victim and in general to the entire community? We are and must be victim focused. And while that doesn't mean that our recommendation, whether it's for charging or not charging or what the outcome of a case should be, is always in agreement with the victim. Again, sometimes people think we're too high, we're too low, we should charge, we shouldn't charge. But our focus is on that victim and our community because we care. The prosecutors in this office want to be prosecutors, and they want to be prosecutors to do what's right. They want to give power and control back to that victim, hold that offender accountable, while also giving that offender the ability for counseling and treatment to make it right. We believe that all people are genuinely good. People are born and raised to be good people. Things happen, and people do some pretty horrific and horrible things. We don't necessarily know why. We try and help them, but our goal and our focus always is that we care, and we want to make sure that that victim survivor knows it and is handled and taken appropriately, and we get the best outcome we can, not only for that victim survivor, but for the entire community. And I think that ultimate care is what leads us in all that we do and how we do it. And we get to all those other areas that I'd love to talk about what victim survivors should know about us and what we do.
Awesome. Well, thank you again. And if you have any interest in reaching out to the DA's office and learning more about them, their contact information is available online. And we'll have a link with this video. Thank you again, Joel, and have a great day.
Thanks. Thank you.